The Chief Justice has been detained or delayed by another matter. He plans to join us as soon as possible, but asks that we go ahead and proceed. So I will call the next case, 115591, State of Kansas versus Donald Raymond Haygood. Counsel?
Good morning. May I please the court, Corinne Gunning, appellate defender on behalf of appellant Donald Haygood, and I would like to reserve 3 minutes for rebuttal, please.
All right, 3 minutes is granted.
Unless the court would like otherwise, I will begin with the first issue from the brief, following a brief factual background, and then discuss the remaining issues if time permits, or if there are other questions. This is a direct appeal from a conviction. Donald Haygood, on the night of September 16th into the early morning of September 17th, was with his girlfriend and her friend. They were drinking, and when they got back to the house, Mr. Haygood got into an argument with the friend Dimitri Mills, and in the course of that argument, Mr. Haygood ultimately shot Mills once in the head, killing her. He was charged with premeditated first-degree murder, and he testified that he believed that Mills was coming towards him with a knife and had shot her in self-defense. The jury convicted Mr. Haygood of first-degree premeditated murder, and he was sentenced to life in prison with the possibility of parole after 25 years. Prior to trial, the state sought to admit evidence of prior acts of domestic violence between Georgie Stallings and Mr. Haygood to prove several different things, and the court admitted those to prove motive, to his motive, the relationship of the parties, and the course of conduct and corroborating testimony of other witnesses. For reviewing the 6455 evidence, this court has unlimited review of the materiality of that evidence, and then abuse of discretion of the probative value and the potential for undue prejudice. In this case, the motive provided by the state...
Well, let's be clear here, that the state asked for 3 different things, or 3 areas of prior crimes or civil wrongs, but actually at trial they only used one.
Correct.
And that was the recent one in which girlfriend Ms. Stallings received a split lip.
Yes.
Was that split lip still visible at this particular time?
To be honest, Justice Johnson, I do not know. Not at the time of trial, which occurred several years later.
And just to clarify, the prior wrong or crime or civil wrong did not involve the victim.
Correct.
It involved the girlfriend that was in the room with him.
Yes, and it's that fact that I believe is problematic for allowing all of these in for these reasons. To prove his motive, the state actually sought to prove the motive that Miss Mills had in calling the police. To prove relationship of the parties.
Which was the motive for him killing her? To stop her from interfering with his ability to abuse his partner. Is it, I mean, that's all motive, right?
The state, I think possibly, but the state's argument is, or was at the time, and in the brief, is that he killed Dimitri Mills to stop her from calling the police. And so the only evidence that was necessary to prove that was she was threatening to call the police, not her reason for doing so.
So what? I mean, if she called the police because she told him to leave, she wasn't the owner of the property, so she couldn't claim a trespass.
Correct.
I mean, it meant nothing. Why would someone shoot someone else that's on the phone calling the police unless they were were in jeopardy of being arrested for something? And how's the jury going to understand that there was something there that she could call the police about if it didn't understand that she feared, Ms. Mills feared that there would be a domestic violence against her best friend, as there had been like a week before? I mean, it's no motive that she was on the phone calling the police unless it impacted Mr. Haygood.
You have to explain why she was calling. in other
Right.
words.
I understand that that is the state's argument, and I think that when you look at everyone says that she called the police, and the corroboration of that too is that she called the police because Mr. Haygood's testimony was he never heard that threat. He never believed she was going to call the police. He didn't know that she had threatened to call the police. His testimony was he had no idea, but that he believed she, in the course of the argument, was coming to attack him. And so.
But the prior crimes or civil wrongs can be admitted if they are relevant to a material fact, correct? And one of those facts here, it's most statutory and claimed here, is motive. And what I'm asking is, why wasn't that prior circumstance in which Mr. Haygood was alleged to have hurt Ms. Stallings an integral part of the motive claim by the state? And you've just said he denied that he was concerned about it, so it's disputed. So
yes.
the motive is disputed. Motive's a material fact, and this is relevant to motive. And why is it not relevant? Make it more likely that he had a motive to shoot her than not.
I guess my argument is and remains that it is not necessary to say and provide a reason for why she is threatening to call the police. The threat to call the police is what the state wants to prove, because that is what's disputed, is whether or not he hurt her, and so that was why he shot her. And I mean, I understand there's this prior act, but it's also, they're all very intoxicated at this point in time. They're in a dispute. He may not, I mean, there's other things that he possibly was facing, besides the threat of a report of an act of domestic violence that occurred a week before that hadn't been reported. For example, he was a felon in possession of a firearm. And so there are a lot of, and he had just done drugs, and he had been drinking heavily, and he was driving while he was drinking. There's a lot of reasons. But the state said, well, the reason that she was calling was to stop him from abusing this person. And that the reason that she's calling the police is not what the state was providing as the motive. It was that she was calling the police at all. And I don't, that ends up being more prejudicial than probative, and it's irrelevant.
You're saying the reason for the call to the police is irrelevant
Yes.
because of the way the state framed the case.
Yes. And I understand the state argued that without that information, the fact that she's calling the police would appear nonsensical, that it would puzzle the jury. But that's not it. That's not part of that's not part of what the jury has to decide, is why was she calling the police. If the state's argument is she was calling the police so he shot her to stop her, the reason for calling the police to clear up any possible jury confusion, again, there are a lot of reasons given the situation why she might have been calling the police, and in fact she ultimately wasn't calling the police. She was mimicking calling the police, I suppose.
But that's the whole point. Why would a threat to call the police, if I were to say right now, if you don't shut up, I'm going to go call the police, you'd say, okay, and what are you going to tell them? I mean, you have to have some reason that the threat would engender action, the teenager on the couch didn't jump up and get excited about the fact she's gonna call the police. Miss Stallings didn't get excited about the fact she was gonna call the police. So, I mean, there's gotta be some reason that threat
Does bite.
prompts action.
And from my argument's perspective, that's, I understand, that's the state's burden to prove this, and I suppose that when they're trying to, it just seems that we're going to try and, instead of accomplishing what 6455 is supposed to, by narrowing so that we don't have all of this extraneous evidence to say, well, he has been abusive in the past, and so he clearly acts abusive, and so he acted that way, and especially he acts that way when he's drunk, because he abuses people when he's drunk, and so here we are, he's drunk and he's abusing people and he killed someone this time. Instead of fulfilling the narrow purposes of 6455, if we get out into all of this extra information, that can possibly lead to improper use by the jury. And as far as the relationship of the parties and continuing course of conduct, this evidence was to show the relationship of somebody who is not a party, not a victim or a defendant, and I don't believe that that's the purpose of those exceptions. And corroboration, again, the corroboration was that the other two people heard the threat to call the police, and so the mere threat to call the police is sufficient in this case. I would, with my brief time on direct argument, like to just briefly discuss the lesser offenses. Mr. Haygood requested an instruction on lesser offense of involuntary manslaughter and then the perfect self-defense instruction, which were denied. But the court did allow an instruction on voluntary manslaughter as a lesser, the imperfect self-defense of that.
And so that's my question. Even if we would find that the court should have given the involuntary imperfect self-defense, why would the jury rejected voluntary imperfect self-defense? Why would they have gone to the defendant's other theory of imperfect self-defense? What is there about involuntary that would have prompted the jury to view that whole imperfect self-defense differently than they did with what was instructed?
I would say it would be because that almost a similar reason as to why the court decided that these two are different than voluntary manslaughter is that imperfect self-defense under involuntary manslaughter requires that you find that he was able to use self-defense and that he just used more force than he was allowed. Same with perfect self-defense, that he was allowed to use force and he used the appropriate level of force. Whereas voluntary manslaughter is based on an honest but unreasonable belief. So they could find that he had a reasonable belief in the need to defend himself, but he just used more force than was necessary to defend himself.
So the elements are different.
They are, yes. And so based on his testimony, which is enough to get the instructions given, regardless of whether or not the jury ends up believing that. I don't think that, I guess the question would be about the skip rule, I suppose, going below, but I don't think that when we're looking at the imperfect self-defense versus a typical voluntary manslaughter, the elements are distinct in a significant way, that the jury could reach those but still reject voluntary manslaughter. And with that, unless there are any questions.
But you're basically saying that the elements of involuntary under an imperfect self-defense more closely fit defendant's testimony of what happened?
Yes.
Because he just says ordinary self-defense.
Yes.
He thought he should have immunity.
Yes.
Okay.
Any more questions? Thank you, counsel.
Good morning. May it please the court. Again, I'm Jennifer Tatum, Assistant District Attorney from Wyandotte County, Kansas, here on behalf of the state. With regards to the 6455 evidence,
Do you mind if you start at the other end, just
Sure.
because we just talked about it?
yes, wherever you like.
Why shouldn't the jury have been given these questions on self-defense and involuntary manslaughter and imperfect self-defense? Isn't our law that the testimony of the defendant is enough to give an instruction?
I don't think that's the law. I know it can be enough, but I think there has to be something that would allow a rational fact finder to accept that testimony. I don't think anytime a defendant testifies they use self-defense, that mandates that the instruction be given.
But didn't the judge have to make a jury call on whether the testimony was adequate under that standard?
I don't think he did have to make a jury call, because what he found from the evidence as a whole, and he wasn't just judging credibility. I mean, we did have 2 eyewitnesses that said, I did not see this happen. I did not see the victim attack the defendant in this case, and I believe I would have seen it. And so maybe if that was the only testimony you had, the judges then maybe taking that credibility out of the hands of the jury. But he took a further step with that, and he looked at the evidence in the case, the physical evidence, which included the testimony of the coroner, the CSI officer, and also pictures from the scene, which and he compared that to the defendant's testimony. The defendant said we were over by the garage, and she came out at me with a knife, and the truth was, based on what the coroner said, is she was shot through her hand, through the phone.
So the judge weighed. I mean, you would agree the judge weighed.
I believe that, yeah, the
But
judge...
that's permissible, you think?
I believe it's permissible. He didn't make a purely credibility call. He listened to the testimony of an expert witness, saw all the physical evidence, and found that no rational fact finder could accept the defendant's, that particular theory of defense in this case. He did give lesser included offense instructions of second-degree murder and voluntary manslaughter, so he did not make a credibility call and completely take everything out of the jury's hands. He also gave an affirmative defense instruction on voluntary intoxication, so he was able to do that too. And I think that's important, because I think by the fact he did give certain lesser includeds, you can conclude he wasn't making a jury call when he did this. He was looking at the evidence objectively and making a call that no rational fact finder could believe self-defense in this case.
So
And-
you're I know you're very familiar with the, kind of our rubric, and we go through factually appropriate, legally appropriate, all that. So are you telling me that the instructions here were not factually appropriate, or that they were not legally appropriate?
I don't believe they were legally or factually appropriate.
Even though they're lessers, they're not legally appropriate?
Well, okay, so with the involuntary manslaughter, it is a lesser. So I guess on that instruction, yes, it could have been legally appropriate, but was
Right.
not factually
Yeah,
appropriate.
self-defense, different kettle of fish, I understand that.
Sure.
Okay.
Yeah. On the self-defense, I don't believe it was legally or factually appropriate.
Okay.
That makes
And the
sense.
factually appropriate, it's not factually appropriate, neither was factually appropriate because you believe the judge is permitted to weigh in order to determine that. I guess let's boil it down. Let me
Okay.
try and boil it down even more. If the defendant's testimony was believed, could he have either ended up with a not guilty verdict because of self-defense or being convicted of involuntary manslaughter?
If it was believed, certainly.
Okay.
But
But the judge is permitted to disregard that and weigh the evidence instead.
I believe so, and I base that on the cases I cited in my brief, including Childers, Alvarez, Bellinger, Gaydon, Knox, and I set forth all of the facts in those cases. They are all cases where a district court judge declined to give a self-defense instruction, and I believe it's permissible to do so if you find that no rational fact finder could conclude that these things applied. With the self-defense statute. I mean, you have to believe there's that objective and a subjective element. So the subjective, like you just said, is there if you believe him, but that objective part was not there when the judge considered all of the evidence in the case, physical and eyewitness testimony together. And so I do believe it was proper and appropriate for him to deny that in this case.
But what's the point of our finding that, which we have in some cases, that the judge should have given the lesser because it was factually and legally appropriate, but we're not going to reverse because it's harmless, because we are convinced beyond a reasonable doubt there's no possibility the jury would have found guilty. We've done that, and so why isn't that the avenue by which the state is protected, or that's the avenue to handle it, rather than letting the judge be a gatekeeper of what's credible and most compelling evidence?
Okay. Let me see if I understand your question, and stop me if I'm not understanding. But first of all, I think if you're talking about self-defense, there is a legal requirement, objective and subjective. And so I don't think that's letting a judge be a gatekeeper on credibility. He's making a finding of fact or law. Based on the facts, he's making a finding of law. So I don't think that's allowing him to be a gatekeeper, him or her. With regards to the involuntary manslaughter, it's a similar standard in that if no rational fact finder could believe that based on the evidence, they're making a decision of law, just like they would on a Fourth Amendment issue or something like that. And I do think it's appropriate for a judge to do that. The alternative would be, if you don't let the judge have that function, that we're just giving every lesser included offense and every affirmative defense in every case. And a defendant could get up and say, hey, I didn't do it. If I did do it, I was drunk. If I did do it, it was because I was coerced. If I did do it, it was because it was self-defense. And then we would have to do that every time. And I don't think that that's fair or constitutionally required in our cases for a defendant to receive due process.
We're in a kind of a strange situation here, because didn't the state not object to the lessers?
I mean, I didn't object to them because I didn't this goes into personal opinions, but I mean, I didn't care. I believed that we had a very strong case of premeditated murder. So I wasn't worried about it, but that doesn't mean that we should give lesser included offenses in every case. I was just trying not to cause
To set
problems.
up an appealable
Sure.
issue.
Right.
And I understand.
Yeah. And I do believe, I mean, you asked me, like, why don't we just focus on the harmless error part in this? And it is because I believe that in this particular case, those instructions couldn't have been given. And I believe this court provides guidance to our district courts. So in certain cases, you do send the message that these things should be given, but if they shouldn't, they shouldn't. And even in this case, if you find that the court erred, I do believe it was harmless error under the facts. And I can recite the facts, but what you have here is a defendant who knew this victim very intimately. Not only was she best friends with this man's partner and mother of her children, but he also grew up with her, and they considered each other like brother and sister. They'd known each other for years. They'd gotten along. There was no history of strife between them. And then they go out one night, and again, there's no arguing. Nothing happens until they get back to the house, and the friend, Miss Mills, says, I don't want you to put hands on my sister anymore. I'm going to call the police. So she doesn't just say, I'm going to call the police. She makes reference to why in front of that child who was at the home and also her friend. And that was because she didn't want her friend to be abused any longer. I don't know why she chose to say it at that moment when there hadn't been any problems. But we also have the defendant during that time frame going back to a bedroom. He says he had his gun the whole night. His partner says, well, that gun's kept in the back bedroom. Doesn't really, I suppose, matter when he got it, but he goes back into the bedroom. He separates himself from that argument with the victim. And then he calmly and coolly walks back in, shoots her without saying a word, shoots her through the phone when her hand's up through her ear, calmly and coolly leaves the scene again, never says another word. And this is the testimony of the eyewitnesses. And then proceeds to use his cell phone, which he's had all night apparently, to call his sister flee the scene, gets involved in this being holed up in this house for 11 hours, tries to hide the gun in a laundry bag. So to me, all of those factors go towards premeditation and make this case an overwhelming one of premeditated murder. So I would ask that you find any failure to give instructions to be harmless. Would you like me to address the 6455 now, or do we have more questions?
I'd like to return to the statute I think that you're referring to, KSA 215108C, which talks about entitlement to an affirmative defense instruction.
Okay.
I don't know that you identified the statute, but you seem to be reciting it. If that statute did not exist, where would we be, in your view, on when a defendant is entitled to an instruction on an affirmative defense?
If that statute did not exist,
Well, you suggested earlier that, at least on lesser included,
sure.
a proposal might be that you just give every lesser included instruction.
I mean,
So I'm asking the same question on affirmative defenses. Do you just say, we're going to instruct on everything that has been raised as an affirmative defense, if that statute was not in existence?
I still think, even if the statute wasn't in existence, I still think our case law surrounding the giving of lesser included instructions would apply. And I don't think our case law requires that. In some of those cases I cited in my brief, but I don't think our case law has ever required that we give affirmative defenses just because the defendant requests them or just because he or she testifies something happened. I don't know if I can give you any better basis than that because I don't.
When you talk about our case law, are you talking about case law that interprets that statute, or are you talking about the common law that this court might have looked at years ago?
I believe it's in common law too. I mean, I'm sure I cited cases that interpret the statute itself, but I also believe in common law. It wasn't required to give an affirmative defense instruction in every case.
All right, thank you.
You're welcome.
I want to turn your attention over to the prosecutorial error issue on closing argument about the voluntary manslaughter being off the table if you find that the knife's not being used. What's your defense for having said that? Seems like a misstatement of law to me.
I think what you have to do in this closing argument is read the entire thing in its totality and not read the lines that were taken out of context in the defendant's brief. I printed a large portion of it in my brief. And I think as a whole, I'm not telling them very simply, if there's no knife, there's no voluntary manslaughter. The whole argument discussed why the evidence and the eyewitness testimony supported that there's not a knife. I believe that the jury is properly instructed. I believe that voluntary manslaughter was properly described by me in the closing argument in terms of the statute and the instructions, and that it was said, this is why he's claiming he's guilty of voluntary manslaughter, because he believes she attacked him with a knife. And that's all he ever says. He believes she was attacking with the knife. And he didn't just believe it, he described it. He talked about where she was at with that knife and what she was doing with it. So it wasn't simply just, I believe there was a knife involved and maybe I was too drunk to see it. I mean, he described it specifically. And I think under the facts of this case, if you don't believe what he said, he couldn't have been guilty of voluntary manslaughter. So I think that was a fair statement in this case, based on the record and based on the law.
So the statement was, in your view, just a summary of, under the facts of this case, in the factual context.
Yes.
This couldn't be not that as a matter of law, if there wasn't a...
Sure. I never said as a matter of law. No, never. Yeah, it was based on the facts in the case, and I went through them very in detail, and I even described why what he said happened couldn't have happened based on the coroner's testimony and where the body was found and things of that nature. So I don't believe it was a misstatement. I have less than a minute left, so I don't want to get started on a new issue unless you want me to discuss 6455. If not, I'll stand on my brief.
Would that otherwise conclude your presentation?
It would.
All right, do we have any questions on 455 or any other issue? All right, thank you, counsel.
Thank you.
I would just like to continue, unless there are other questions on the jury instruction issues. As far as the perfect self-defense, I would argue that it is legally appropriate. From a legal perspective, there are particular legal exclusions for perfect self-defense, mutual combat, initial distress, or reckless crimes. The determination of the objective and subjective factors is a factual question, and so because none of the legal exclusions apply, I would say that that would be legally appropriate.
The only evidence of self-defense or imperfect self-defense was defendant's testimony that the victim came at him with a knife.
Or something that looked like a knife, yes.
Or something that looked like a knife.
Mm-hmm.
And that he shot her as she charged him or came at him.
Yes.
Correct? The victim was found in front of the wine rack, laying on the ground with the cell phone underneath her. She had the round went through her finger, went through the cell phone, went into her face and into her neck.
Yes.
And given that, and there's a picture in the record that shows where she's laying,
Yes.
and they found the cell phone underneath her when the first responders came.
Mm-hmm.
Given those facts, how can we say that the failure to give those self-defense weren't harmless? I mean, the physical evidence does not support, in fact, makes it impossible for the defendant's scenario to have happened, wouldn't you say?
No, I'm not gonna. I wouldn't concede that.
Right.
I think, and the way that the law has developed has turned into this question where we don't even, as long as it's harmless, then we don't care what the district court judge does. And I think that on opposing counsel's argument, when you get to the question of why not give these, because what's the harm? The problem is that we're addressing this on appeal, and all of the case law that's directing the district courts is coming from, well, they didn't give it, so we're going to say it's okay. But in this case, the harm is that the jury was not given the opportunity to actually even consider.
But this isn't structural error, is it? We don't say the failure to give a lesser is structural error, and if it's not structural error, it's harmless error, and if it's harmless error, we apply our standards. And the strictest standards is that we have to be convinced beyond a reasonable doubt there's no possibility the jury would have been affected by it. And that's the point at which we look at the physical evidence and make that determination, right?
Yeah, that there's no reasonable possibility, but as long as there is testimony and there's evidence to support it, I would argue there is a reasonable possibility that the jury could have found it differently. And I did argue...
And what is the reasonable possibility? Because that's a little bit of what the judge is, by statute, is doing here, is looking at the evidence, and even in spite of every affirmative defense, that and the kind of the weighing and what you have to demonstrate is supported by competent evidence. And there's a statement made by your client that he thought he was being attacked by her with a knife, but there's all this other evidence that Justice Johnson just pointed out. What prevents the court from sitting and weighing that evidence and just saying, no, there's just no possible way for the defendant's scenario to support the instruction?
What prevents the judge from doing is that the judge is not the fact finder. The jury is the fact finder, and if there's a dispute between the defendant's testimony and the facts...
who determines what's supported by competent evidence? Isn't that what what you're entitled to, an affirmative defense that's supported by competent evidence. Just anything is competent evidence? You can't look at the entire scenario and say, no, it's not supported by competent evidence.
Obviously that is the standard, and that's what the judge does, but he is, rather than viewing the totality and saying, I mean, there's a difference between saying, no, this wasn't robbery, I'm not going to give you a robbery instruction, but that there is a dispute between your statements and the physical evidence, and the resolution of that dispute is the jury's decision
So
to make.
in any case, as counsel pointed out, a defendant can get up and say whatever to get an affirmative defense. Just say it, and that's sufficient, even though there's no other evidence that points in that direction. Just make it up.
I will say from my perspective, I would say yes, because it's very minimal if there's any evidence, and a defendant's testimony is in fact evidence, and if there's any evidence to support giving the instruction, then I don't know, you get to it once it gets up here, or to the Court of Appeals, the question then is like, but what's the harm? So what is the harm? And so this may be decided on harmlessness, but the court in this case resolved all the factual disputes against the defendant, which is not what is supposed to happen, and made these factual findings that essentially then instructed the jury that his version of events is legally unreasonable, and he is not to be believed.
Any more questions? Any further presentation?
No.
All right, thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.